All right, good evening. I'm going to get started right away. Uh, this is a review of classes one and two. For those that have attended class one and two, I've had a few video issues with getting things recorded for those who were not able to attend or for those that just wanted to review the course. So, what I decided to do instead of messing with Zoom, trying to dig up the old recordings, which I apparently did not properly save or something like that, we'll have it right for the upcoming weeks. But for this particular week or the last 2 weeks, I'm just gonna do this kind of fresh review. Hopefully, knock it out in maybe 15 minutes and not take too much of your time. Again, for those that were not able to attend, and for those who just want to kind of review of where we're at, especially after the last class, because we really took off in the last 20 minutes, and I know some people might have had their jaw dropping. So I just want to put you right in the context. You're right where you're supposed to be. We've done a lot and we're going to rehash a lot of those concepts throughout the year. So by the end of the semester, a lot of the terminology, those theories, and statutory interpretation, all that will be some second nature. All right, so let's just tear through this real quick. In the first class, you all may recall that I introduced myself. I'm the director of Economic Justice Law Review. It's the repository for scholarship relating to race, economics, and the law. And I particularly have an economic perspective when it comes to law and critical race theory, much more than probably a lot of other people do. So, what we're going to talk about a lot is how law affects the racial wealth gap. Okay, for me, that is the basis of structural racism, the systemic racism. Others will expand that to other areas and dynamics, and we'll talk about that too. I formerly taught at Howard University, Widener University, Delaware, Florida International University College of Law, and also Penn State Dickinson. A federal former tax court clerk, clerk for Judge Foley, who also teaches at American, who is now the current chief judge at the U.S. Tax Court. I've taught federal taxation. That is my main specialty. Administrative law, sports and entertainment law, hip hop and the law, critical race law and economics. I've written 3 books, over 15 law review articles. Um, Again, we'll reference maybe them when they're appropriate. The goals and expectations of this class, it is my goal to give you the terminology, the vocabulary to place critical race theory within general legal jurisprudence, right? Critical race theory criticizes legal jurisprudence. However, as lawyers, we do have to deal with it. If we're going to be effective in appellate argument, if you want to be a Supreme Court clerk, uh, I would like to help you get there. I would like you to learn the terminology and specific techniques of how we're going to consider or ask judges or even executive administrator within the federal government, how we're going to have asked judges to consider race, gender, any type of anti-subordination within the law when there is a dispute about what the law ought to be, right? We're approaching law as a language, right? You understand what fairness is, you understand what justice is. We could get a PhD in justice. You could get a PhD in ethics. But when we're talking about the law, we're talking about a specific language that's used within our profession and how critical race theory um, finishes in with that, fits in with that. The overarching theme about quality is I'm asking you to write to teach, right? We're going to teach the Supreme Court. We're going to teach our client. We're going to teach our senior partner. You're going to teach me, the professor. You're going to teach me through your writing, right? So that IRAC, issue, rule, analysis, conclusion that didn't go anywhere, we're going to incorporate how to discuss racial subordination and other types of group subordination within that rubric, within IRAC, within the constructs of textualism, intent, purpose, modern dynamics, etc. Again, our final writing product, we can call it a paper. I know some have asked if they can use this class as an upper level to satisfy their upper level writing requirement. I'm all for it. I love papers. I want you to teach me. I want you to have an issue in the law how the law somehow, somewhere harms a group that you care about, and teach me how that is. And hopefully we get to specific statutes, specific laws that cause the effect, and perhaps even some solutions. So that begs the question we dealt with in class one: what is critical race theory? I posit that it is, if we had a very simple term for it, it would be anti-group subordination law, right? How the law subordinates, contributes to the subordination of specific and discrete groups, or how the law can be used to ameliorate that subordination, how it can be used to address social subordination in the United States of America. Now, again, we started with race, but very quickly we see how critical race theory expanded towards lat, crit, and ethnicity. Of course, with gender, we can deal with religion, sexual orientation, and any intersectionality amongst them, right? The way in which law subordinates Black women, for example, as Kimberly Crenshaw is the originator of both the term critical race theory and intersectionality, right? We discussed very quickly in class one a chronology of critical race theory. I write in Hip Hop and the Law. I'm very fortunate in my lifetime. I just turned 50, and since I was 5 years old, basically, I got to witness the birth and expansion of both hip hop and critical race theory from almost nothingness, and almost, because they all had an origin somewhere, a kernel, a spark, right, of things that came before it. But acknowledge that it has been birthed in the 70s, that in the 80s it began to take form with conferences, that nationwide in the 90s, where every record label by the 90s had to have hip hop artists, every college and university, law school had to have critical race theorists by the end of the 90s. In 2000, it went interdisciplinary and global, just like hip hop spanned from hip hop to R&B, country music, etc. in the 2000, to the point now where it's ubiquitous, right? And with that ubiquity becomes a certain formlessness. So just like it is very hard to say something is or is not hip hop, is trap music hip hop or is it something different? Same with critical race theory. Is any scholarship we produce relating to race critical race theory, right? Is any scholarship you write on women critical theory, right? And in that respect, Nas, the artist, asks, "Is hip hop dead?" And in terms of the law, I don't think we're anywhere close to that. Neither are we with hip hop. But one might ask, there's a scholarly trend towards what's called Afro pessimism, which seems to, on the one hand, extend from critical race theory, but at the same time seems to fight back against critical race theory in a certain way. We're going to talk about a little bit of that. So we introduce our text in class one. We're going to be using Kiara Bridges, Critical Race Theory, a primer. Our first two classes dealt with her, chapter one and chapter two. Please have questions. If you still have questions about some of the terminology or some of the themes that she discusses in chapter one and chapter two. Derek Bell's Faces at the Bottom of the Well, which I think is a very good contrast to Bridges. Bridges, in fact, calls Derek Bell's approach a conservative approach, which is very interesting. On the other hand, you have Derek Bell's book with the foreword by Michelle Alexander, who is the author of The New Jim Crow, probably the hottest book in critical race theory of the 21st century. And all the way following through to his Afro-Lanica Awakening in chapter two. Again, if you have questions about those, please raise them. My preference is for you guys to ask questions, because if you just let me talk, we can go all day. So I really want to know where you guys are at with all this stuff. So let's talk about Bridges' book first. We talked about Bridges in class two, right? We talked more specifically about her description or her use of the terms conservative, liberal, progressive. And as a shorthand way of understanding these terms, we could think of life, liberty, and property in the Constitution. And we could assign conservative, or what she calls conservative, as a concern for property, right? There is a cadre of neoconservative scholars, or you could associate it with what people call right wing. The judges that are considered conservative judges have been appointed by Republican judges. Now, again, I always put question marks about these because they fall apart at some point. Not everybody falls in line with all these theories. So I just want to be fair. The term liberal, of course, emanates from the term liberty, right? That everyone has personal liberty. And the purpose of the law is to support that flourishing of individualism, right? Neoliberalism is a hot word nowadays and often very well criticized, as a matter of fact. Liberals are considered or perhaps think that they are moderates, although progressives think that they are right leaning. The liberal justice of the Supreme Court were appointed by Democrats. Um, that critique or the critical theory, especially from Professor Bridges' perspective, seems to come from what's called progressive ideology, which seems to be a concern for life, or the idea that government's job, on the one hand, if you're conservative, the government is supposed to protect property. If liberal, the government is supposed to protect your individual liberty. Whereas progressives believe that government should be active in protecting everyone's life and helping them fulfill that life. It is often associated with socialism, although it doesn't necessarily have to be. You have left wing or the Green Party, and again, these descriptors are not precise. So you could have we'll just leave it at that. I want to, we're just reviewing, so I don't want to get into many of the weeds. But again, if we were applied to her terminology to the Supreme Court, when she talks about conservative discourse, she is generally talking about the justices appointed by the Republican Party: Thomas Alito, Roberts, Kavanaugh, Gorsuch, and Barrett. Now, just like Anthony Kennedy in the last regime, the Roberts Court seems to have Roberts as something, some will consider him to be more moderate than they believed he would be to begin with. There are three liberals still on the court. Stephen Breyer is the longest serving, then Alita Kagan and Justice Sotomayor. As we know, Obama was not allowed to replace a justice on the Supreme Court. And therefore, when Trump got two, that wildly switched the balance from 5-4, which it had been for a long time, to an overwhelming conservative majority of 6-3. There are no Supreme Court justices that outwardly consider themselves progressive. None of them consider themselves critical race theorists either, right? So as far as Justice Sotomayor, just because she is a woman of color does not necessarily mean she considers herself progressive. I'm not sure if she does or she doesn't. And with her writings, as far as the law professor is concerned, I know it is not clear whether she just specifically identifies as a critical race theorist, right? It's very interesting. I just put a note that some people note that there are 6 Catholics on the Supreme Court. That I believe it's Thomas, Alito, Roberts, Kavanaugh, Barrett, and then Sotomayor. So it's very interesting that out of 9 justices, 6 are Catholic, when the percentage of the population, or even percentage of lawyers in the country, or even law professors in the country, is not 2/3 Catholic. Just interesting. I don't have any other. There's no there for me right here. But it could be for you. I don't know. Uh, we followed up Kiara Bridges' discussion of socio-political ideologies and what some may call epistemologies with Derek Bell's theories, right? Derek Bell approaches critical race theory somewhat differently, right? His is about the permanence of racism. If we saw that racism, if we agreed that racism was permanent, we would probably approach the law differently than if the way Kiara Bridges would approach it. So Derek Bell is the author of several theories. One is called racial realism, and at the heart of it is the argument that racism or racial discrimination, racial bias, and again, what is racism is a whole question of itself, but that racial realism, racism is permanent in the United States. It is durable. It is indefatigable. He argues further that laws are passed to further racial justice, when it is in the interest of elite whites to do so, this interest convergence theory, right? He has other theories as far as the rules of racial standing, which is not that relevant at the moment. We'll also talk about his concept of Afro-Lanica, because I think that's also important when we talk about statutory interpretation and new models and modes of how to do it. But I want to focus really quick on just this review about Michelle Alexander's Forward, because again, her book is probably the most popular book on that can be considered critical race theory in the 21st century. And she is I'm not going to call her a devotee of Derek Bell, but she is certainly one who believes also that racism is permanent. This reflects a divide in scholarship between Black academics. And again, we have to, for those that don't know, we're presenting today that Black people are not of one mindset, and neither are Black academics or politicians. So there is a cadre of Black scholars who promote anti-racism. Kiara Bridges' book is consistent with that. You are all familiar with Professor Ibram Kendi, who taught at American, and American University has embraced anti-racist pedagogy. However, there is, on the other hand, a cadre of Black scholars called Afro-pessimists who argue that racism is in fact permanent. It is a sin no different than, or hardly different than, greed or crime or violence. They are things that you address and you approach it constantly. You never give up. You never relent to crime. You try to minimize it as possible. You deal with the victims of crime, but you do not approach crime as if you're going to ever get rid of it entirely. And that is Michelle Alexander and Derek Bell's approach to race. And so we're going to see that it's almost like keeping it real, as we say in hip hop, versus the audacity of hope, right? On the one hand, do we hope that things get to a place where we've never been, or do we deal with how things are and have been up until this point? Which should the law deal with, ideals or reality, right? So we're going to continue along that theme in this next, in class number 3, of course. Now, we finished that last class off with a discussion of what was meant by legal realism, because Kiara Bridges argues that critical race theory is within legal realism. It emanated from critical theory and then tries to place itself in realism. We'll talk more specifically about that, but I needed to give you a whole overview of how the law thinks in legal theory and jurisprudence in order to start talking cogently and coherently about this. So we're going to break legal jurisprudence into 3 major categories and focusing on the first 2, formalism, realism. Why? Because no judge in the United States, in the appellate courts or the Supreme Court, openly, avowedly admits to being a critical theorist. They will admit to being a formalist, some will admit to being a realist, but none admit to being a critical theorist. So by formalism, we mean the text. I'm sorry, we should have put it up there. No vehicles in the park. How do we determine whether something that's been created 100 years after the statute is passed, how do we determine if that thing, a gas-powered wheelchair that goes up to 40 miles per hour, is that a vehicle in the park such that it should get a citation? How do we justify it? Because we can't just say it is or it isn't. So our first means of trying to justify it is saying, what is the plain meaning of the word vehicle, right? Is the sentence or the law written in a certain way? Are there statutes around it that give us insight into what the original statute meant, right? So is a drone, is a child's four-wheel, is an ATV, a Segway, right? What are those things within what the people understood to mean vehicle to mean. Text focuses on what the listener understands, what the people understand. Intent is the opposite. It focuses on what the writer intended, what was in the mind of the writer, in the mind of the author, in the mind of the legislator. So text, what does the reader think it is? Intent, what does the writer think it is? How do we glean that? What evidence suggests what the writer thought? So-called legislative history. Committee reports, conference reports, the writings that where they try to explain what the law is. And then we can expand the definition of legislative history very broadly to include judicial precedents and administrative interpretations. When you see the court citing the courts before it, there's an assumption that the legislatures are aware of those judicial interpretations and they accept them so long as they didn't overturn them. So that is called formalism, right? And note that formalism had no concern for what the law is going to do to anybody or anything. It's just trying to figure out what is meant. Formalism deals with meaning. Realism deals with consequences. What is the consequence that will be produced or avoided if we interpret vehicle in a particular way, right? Text, what do people think vehicle meant? Intent, what type or form of vehicle did the legislature think of? Big vehicle, small vehicle, loud vehicle, four wheels? What form did the vehicle take in the minds of either the legislature or the public? That's formalism. Realism, what does it do really? What does it do in reality? What type of consequences? Meaning, consequences. Formalism, meaning, realism, consequences. So, purpose are those consequences that are tethered to legislative expectations, right? On the one hand, they could think that a vehicle had a particular form. That's four wheels, doors, gas powered, whatever. Realism asked, what were they trying to do when they wrote the law, no vehicles in the park? Were they trying to stop accidents? Were they trying to stop noise pollution? Were they trying to stop air pollution? If legislative history shows that they were trying to stop noise pollution, then should we give citation and impinge on the liberty and property of citizens if what they carried into the park doesn't cause any noise pollution, right? Should the law be limited or by its purposes? Should it be shaped by its purposes? Modern dynamics is often called judicial activism, and this is judges considering consequences that neither the legislators spoke on nor intended, right? It's them talking about things that they find important to them. It is considered anti-democratic. So most judges do not admit to considering modern dynamics. I've mentioned one judge, Judge Posner, who admittedly did, and that's why he never became on the Supreme Court. So this is the way the law talks in judicial opinions: text, intent, purpose, modern dynamics, formalism, realism, meaning, consequences. And then critical theory says law professors come along afterwards and try to say that this, regardless of whether it fit the text or intent, or regardless of the purposes and modern dynamics that it promoted, we argue or that this opinion did not respond to the precepts of justice, however constructed, right? And that appeal to justice can be very formless, right? So that's a whole class in statutory interpretation. We're going to review this all the time. As a matter of fact, this very next week, we're going to deal with the Byron Allen case, right? That's Comcast versus the National Association of African-Owned Media, where Byron Allen said that he was discriminated against in his pursuit of a relationship with Comcast to distribute his cable channels, right? So he relied on the Civil Rights Act of 1866, right? Section 1981 of the Civil Rights Laws of Title 26. And so Gorsuch's opinion is written in a style that is formalistic. He deals with text. He also deals with judicial precedents. So we can also get that intent in there. Ginsburg's concurrence is an example of realism. She talks about what the Congress of 1866, what it was trying to accomplish. She uses its legislative history to offer proof of what they intended, how broadly they thought the law should be interpreted. And we're going to relate that back to Derek Bell's uh, theories on interest convergence. Is the reason why Comcast, the Byron Allen case came out, because it did not fit the interest of elite whites. And then secondly, from an Afro-pessimistic view, is it even better to pursue this, or would it be more beneficial to have what Derek Bell called a racial preference licensing act? What does he mean by that? Cutting it off there because it's getting too juicy. So we're going to see you guys tomorrow, 8 o'clock to 9:50. See you soon. Hope you enjoyed this breakdown. And see you tomorrow. We're out. Hotep.